Ma'am, your slides are not visible, ma'am.
Okay, okay, sir, I will share.
Okay, ma'am.
Good afternoon, everyone. Our respected speaker and energetic participants, a very warm welcome to this technical section on the topic filing of patent, format and procedures. I am Muhammad Rafi, first year LLM student, Department of Law, Central University of Karnataka, your moderator of this technical session. We are truly privileged to have with us a distinguished guest, Dr. Deepa Boppana. Now I would like to invite my friend August, first year LLM student, Department of Law, Central University of Karnataka, to introduce our esteemed speaker.
Good afternoon, everyone. I welcome you all for this faculty development program. I am very happy to welcome our speaker, Dr. Deepa Boppana. She is a well-known patent attorney with a PhD in analytical chemistry and a degree in law. She has won awards like the Women Scientist Scholarship from the Government of India for her work in intellectual property rights. Dr. Deepa, her own firm, her own IP firm, Bhavesh Associates in Chennai, and helps industries, universities, and research labs with patents. She is also a legal expert for many organizations, including medical colleges and hospitals. Today, she will share her knowledge and experience in IPR, which is very important in today's world of innovation. Ma'am, please, you may go ahead. Thank you.
Thank you, sir. Thank you for the nice introduction. Am I audible?
Yes, ma'am.
Okay. I think slide is also visible, right, sir?
Yes.
Yeah. First and foremost, I would like to express my heartfelt gratitude to the management and the organizers for inviting me to deliver the lecture on the said topic. The topic goes like this: filing of patent, format and procedures. Okay. Before going into the format and procedures, we will just have an introduction of what is a patent. Patent is a protection granted by the national government for an invention. So people used to think patent is a scientific invention. Actually, patent is a right. Patent is a protection, and it is a monopoly right, and it is granted by the national government. And then, since it is granted by the national government, if you want to protection in India, you have to file your patent application in India. If you want to get protection in US, you need to file application in other US. Likewise, so which is you have to file the protection in each country individually. So this is the important criteria. If you want to have the protection in Japan, you have to file an application in Japan. Okay. And then what I said, it is a right. So what right you are getting means you can exclude others from making, using or selling an invention for a period of maximum 20 years. So this is the right you are getting. I must say it is a negative right because it is excluding others from market, manufacture and use. Okay. For an invention to become a patentable subject matter, the invention should go through three important conditions. That is, the invention should be new, useful, and non-obvious. So these are the three essential conditions for an invention to become a patentable subject matter, right? And then in India, it is enshrined in Patent Act 1970, and it is operative whole of India. Next comes the object. What is the object? To enjoy the exclusive rights over the invention. See, if you are coming out with an invention, you are investing time, money, energy, everything, right? And if you are doing a research and getting out of a product and somebody is copying and launching the product in the market, getting profit, it is not right, right? So in order to have an enjoy the exclusive right over the invention. Of course, to encourage scientific research, new technology, and industrial progress. So it is a sort of encouragement to the scientific research. And of course, to ensure commercial recurrence, because you have spent money to arrive at a product, you have to get back this. And this was taken from a Supreme Court judgment where the object of or patent law is the disclosure of the invention at the patent office, which after the expiry of fixed period of monopoly passes into the public domain. So this is the ultimate object of the patent law, because government want to have a balance between both the patent holder and also the common public. So in order to give a monopoly, the patent office will grant you monopoly only for a particular period of time. That is, as far as patents, it is 20 years. So after which it has to be come to the general public, right? For which you have to completely disclose your invention in the patent office. Complete disclosure is essential. Okay, so a crisp definition of what is a patent is a monopoly right. It is a right granted for an invention. This is for an invention by the government to the inventor or his assignees for a limited period. So this is the definition. So a patent is I said it is a right, monopoly right. It is granted for a scientific invention. By whom? By the government to the inventor or the assignees. If you are using the infrastructure of the college or the employer, then the employer or college will be the owner of the patent. And it is for a period of 20 years. And it is valid within the country of grant. I said earlier, right? So if you want to have protection in India, you have to file your application in India. I said it is a monopoly right, right? So what right you are getting here is no one else can make, use, manufacture or market the invention without the consent of the patent holder. This is the right you are getting. So which means you can prevent others from market, manufacture and use. So these are the right, monopoly right. And for an invention, for a scientific invention to become a patentable subject matter, these are the three conditions which need to be satisfied. I must say, a statutory pillars for patentability. That is novelty, inventive step, and industrial application. So these are the three conditions to become, for a scientific invention to become a patentable subject matter. We will see one by one. What is novelty? Novelty means new. It should be new, right? So it should not form the global state of art. Just look at the word global state of art. Throughout the world, it should be new. So what is the state of art? That is informations appearing in magazines, journals, books, newspapers. These are all. If your invention is already available in a newspaper or a journal or a magazine, then there is no novelty for your invention. And one more important thing is, you are not supposed to disclose your invention in any workshops, conferences, seminars, etc. Because that also will destroys the novelty. And then your prior use of the invention. You are not supposed to use your invention before filing the patent application. So for an invention to become a patentable subject matter, one of the criteria is novelty. Novelty means it should be new throughout the world. And what is that state of art means? Journals, newspapers, conferences, etc. And novelty is, as I said earlier, it is assessed in globalized context. It may be new to India, but it is not novel if it is already existing in the other parts of the earth. Next comes inventiveness. Inventiveness, that is non-obvious. Inventive step means a feature that makes the invention non-obvious to the person skilled in the art. I will explain this inventive step with a very simple example. For example, person A, okay, person A, he has invented, he has enclosed a tungsten filament in a circular glass enclosure and named it as a bulb, okay. And person B comes out, he has done a research and he has done enclosed this same tungsten filament in a tubular glass and named it as a tube light. Now the question arises whether the tube light is inventive over the bulb, circular bulb. And then there comes the inventive step, that is non-obviousness. If a tungsten filament glows in a circular glass, it is obvious that it will also glow in a tubular glass tube, right? Cylindrical tube also it will glow. So this is obvious. This tube light is obvious with that of the bulb. Your invention should not be obvious. So that is what Inventive step. What Act defines inventive step is it should have technical advantage or economic significance or both. Okay, so the Act simply defines it should have, your invention should have technical advantage or it should be cost effective. Then the invention is said to have an inventive step. Then use. This is also one of the criteria for an invention to become a patentable subject matter. Your invention should have utility. See, because you are spending time, energy, money, everything to come out of an invention which doesn't have any use, then what is the point of doing the research, right? So, no valid patent can be granted for an invention which is devoid of utility. Let us see some definitions in the Indian Patent Act. What is invention? These are all from section 2. What is invention? Invention means a new product or a process. So here, I think being a law student, you will be knowing that what does means it reflects. Means only this one. If in Act, if it use the word includes, means we can add some other things also, because here it is said invention means only this is the invention. It has to be new. Okay. It has to be either a product or a process. So there is no use patent in India. Okay. So your invention should be a new product or a new process, and it should involve an inventive step. What is inventive step? Technical advantage or cost effectiveness. Okay. It should involve an inventive step and capable of industrial application, which means it should have some use. So this is what Act defines. Invention means a new product or a process involving an inventive step and capable of industrial application. And what Act defines inventive step implies technical advantage or economic significance or both. That is what inventive step. What is this capable of application? Capable of industrial application means the invention is capable of being made or used in the industry, which means it can be either a raw material or an end product to an industry. So this is what the definition of an invention in Indian Patent Act. I said right from the beginning, if an invention to become a patentable subject matter, it has to be new, useful, and non-obvious. That is, it should have technical advantage. If all the three conditions are satisfied, and if it falls under section 3 and section 4 of Indian Patent Act, then it is non-patentable subject matter. So what is section 3 states? Section 3 states what are not inventions. Section 3A states that frivolous or obviously contrary to the well-established natural laws. That is, if somebody comes out with a time machine where you can go to the past or to the future, which is against natural law, right? So no patent shall be granted for that as per section 3A. Section 3B states, contrary to public order or morality, prejudice to human, animal, or plant welfare or health. That is, if somebody comes out with a biological warfare weapon or a novel method of committing theft or burglary, so which is against public order or morality, which is non-patentable subject matter. And then mere discovery of scientific principles, abstract theory, living things and non-living. That is, section 3 states that discoveries are non-patentable, only inventions are patentable. That comes, what is the difference between the discovery and the invention? Newton's law of gravity is a discovery. Alexander Graham Bell's telephone is an invention, right? Okay. So telephone is patentable. Law of gravity is non-patentable subject matter as per section 3C. Section 3D states that mere discovery of new form, new property, new use of a known process, machine or apparatus, etc. is non-patentable subject matter. Just section 3D states that new use of a known compound is non-patentable. So this is a famous example, aspirin. Aspirin, we all know it is having pain relief, that is analgesic property. Later, it was found that it is having excellent cardiovascular property, and they have filed a patent for cardiovascular property of aspirin, that is new use of the known compound, which is non-patentable under section 3D of Indian Patent Act. Next, section 3E states that mere admixtures are non-patentable. For example, if you are mixing 3 components, for example, A, B, and C, all the 3 are having anti-diabetic activity. A is having 10%, B is having 10% and 3 is also having 10%. If you mix all the three, if you get only 30%, then it is additive mixture, which is not patentable. If you mix all the three and you are getting the efficiency as 80 or 90%, which means there exists some synergism in the three combinations, right? So for that, synergistic mixtures are patentable subject matter. But if it is just an additive mixture, that is admixtures, it is not patentable. Section 3F. 3F states that mere arrangement, rearrangement, duplication of known devices is non-patentable. Actually, it is a very good invention, umbrella cum torch. During rainy season, during night time, it will be useful, right? Actually, it is non-patentable because umbrella is already known. Torch is also known, right? Mere arrangement and rearrangement are known devices is non-patentable under section 3F. And then method of agriculture and horticulture is non-patentable under section 3H. And method of treatment is not patentable. That is here in vivo treatments, that is surgeries, performing the surgeries or removing the tumor from the human body. That is, if the invention is treating the human body, it is non-patentable. But however, surgical, therapeutical, diagnostic instruments or apparatus, that is, if you are devising a novel surgical tool or a surgery knife, such kind of things is patentable. And then diagnostic methods, that is, you are taking the sample from the human subject, for example, blood, saliva, urine, and you are doing the test in that sample to detect the presence or absence of certain diseases. That detection method of a particular disease is patentable subject matter. Only the treating the patients in vivo treatment is non-patentable in India. And then plants, animals, including seeds, varieties, species, biological process, these are all non-patentable. And it is protected under yet another act, that is Protection of Plant Varieties and Farmers' Right Act. And then mathematical, business methods, computer programs, per se algorithm. That is, these are all non-patentable subject matter. So computer programs, software per se is non-patentable. But if you embed your software in a hardware, then you can get the patent right for that hardware. And then literary, dramatical, musical, artistic, or other aesthetic works. These are all falls under copyright, non-patentable subject matter. Mere scheme, rule, method of performing mental act, playing games, these are all non-patentable. And then presentation of information, IC circuits, topography of IC circuits, and traditional knowledge. So there is no patent right for neem, turmeric, basmati rice. I think I made you clear what are the inventions which are non-patentable under Section 3 of Indian Patent Act. Section 4 states that no patent shall be granted in respect of an invention relating to atomic energy falling within subsection 1 of Section 20 of Atomic Energy Act. See here, if your invention is having radioactive substances like uranium, thorium, plutonium, or gamma radiation, or if it involves alpha radiation, they won't simply say it is non-patentable subject matter. The patent office will send the invention to DAE, Department of Atomic Energy, where they will check whether there is any harm to the society or to the environment or to the human public, or if there is any secrecy directions in our inventions which is related to defense sort of thing. If everything is not there, then atomic energy related inventions also patentable. Only thing is they have to pass that scrutiny test of DAE. Okay, so this is what. Now I think I made you clear what are all the patentable subject matters. So the first three conditions is it should be new, useful, and non-obvious, and it should not fall under Section 3 and Section 4 of Indian Patent Act, right? The next question is when to file a patent application. The answer is earliest possible date, and it should not be delayed. Once you got an invention, you actually, one of the criteria is it should be new, which means you should not disclose it to anybody, right? You have to immediately go and file your patent application. So what will happen if you are not filing the patent application? Means other inventors, who are working in the same field can file the invention, or you yourself can inadvertently publish or disclose your invention in in conferences, everything, these are all will destroy the novelty. So the answer to this question, when to file a patent application, is earliest possible date. Next, as far as this is very important question for an academic institutions, can a published or disclosed invention be patented? So this is very important. The answer is no, because once you publish, it will destroys the novelty. Okay, so for that reason, if you have got a scientific invention or your client is having scientific invention, advise them not to file a patent application, not to file a journal or disclose that in the conference. First, they have to file the patent application, and then they go for the same invention, they can go for a publication also. So these are the two essential documents for patent filing. One is provisional specification and the second one is complete specification. For provisional specification means preliminary. You have an invention, and on the pilot studies, you are very confident that you will get a good results in the final product. In such a case, in order to establish the early priority date, you can submit your application as provisional specification to the Indian Patent Office. Okay, but Indian Patent Office will give 1 year time period. Within that 1 year time period, you have to file the complete specification, which involves the complete details of the invention. So these are the contents of the specification. So this is how your specification should be. First thing is you have to file the type that it should have a title of the invention. It should have the field. If it is a drug for treating diabetics, then it will be in the field of medicine. And then what is the background of the invention? So in the background of the invention, what we need to write here is, for example, if you take diabetics itself, you have to mention what are the diabetics, what is the diabetics, what are the symptoms of this diabetics, what are the causes, and what are the available medicines for diabetics. Okay, that you have to write. And then you have to mention what are the disadvantages faced by the available. Because if you are working for an invention, means it should have some advantage, right? For means like it should be the previous state of art should lack some disadvantage. This is very important. You have to mention what is the disadvantages faces in the prior art. And then what is the object of, next comes the object of the invention, where you have to give what are the objects. And then the summary is the crisp definition or abstract of your invention. It should comes in the summary. And then if your invention is having drawings, you have to briefly describe the drawings and detailed description of the invention. That is starting, if it is a diabetics patent, first you have to write what is the invention, what is your product, and what is the conditions for arriving at the product. If it is a process, you have to mention the process of the product. Everything you have to write there. After that, what you need to write is, this product is subject to experimental studies to ascertain its anti-diabetic activity. So for which you have to give some experimental details of that activity. And finally, you have to end with working examples. So why this thing, working example? This working example should clearly describe the best method of doing the invention. Because after 20 years, it should be open to public. Anybody a person skilled in that has to reproduce their invention, right? So for which you have to completely give the working example. And claims, this is the techno-legal part of the document. Claims is the techno-legal part for which you are sorting the protection. So for drafting this, for drafting, here comes the role of a patent agent or a patent attorney, where he or she will draft accordingly. They will make sure that they will completely cover the entire boundary of the invention and also ensure that they are not infringing the other inventions into our claims. And then abstract, it should have the abstract. This claims and abstract is not required for provisional. If you are filing the provisional, no need to give the claims and the abstract. Only in the complete specification only we have to give the thing. So I said, provisional specification, what does it should contain? It should describe the essential features. Just essential features of the invention is sufficient. And claims and abstract is not the part of the provisional. Fees is same fees only. And then this is very important, complete specification must be filed within 12 months from the date of filing the provisional application. Okay, this is the time limit for filing the complete when you are filing the provisional specification. And then coming to complete, it should contain full description of the invention and its operation, best method of making the invention. So you can see for provisional, essential features of the invention is sufficient. Whereas for complete, best method of making the invention must be disclosed in the complete specification. And it should end with claims, and it should accompanied by abstract. And if the invention is having biological materials like strains, DNA, microorganisms, which cannot be explained in a black and white paper, in such a case, we need to deposit the material in the International Depositing Authority, which in India, it is in IMTech Chandigarh. And then they will give an accession number. That number also we have to mention in the patent application. This is for if your invention is involving biological materials. Next comes grant of the patent. So first we have a scientific invention. We have got an invention and checked whether it falls under, it is novel, useful, and industrially applicable, inventive. And then it does not fall under Section 3 and Section 4 of Indian Patent Act. Next comes, you have to draft the application, and the application has been drafted. Next is, we are going for the grant. The three important questions are, who can file, where to file, and how to file a patent application. Who can file? The inventor has the right to file. It is called as true and first inventor or assignee. If your college is assigning you or the employer is assigning to the employee, then the employer or the college has the right to file. And since it is an intellectual property, it is property, legal representative of any deceased person or an assignee has the right to file the patent application. That is what. Where to file the patent application? In India, there are 4 places: Chennai, Mumbai, Delhi, Kolkata. This is South India will fall under Chennai Patent Office, where Kerala, Tamil Nadu, Karnataka, Andhra Pradesh, Telangana, Puducherry, that union territory, everybody falls under Chennai jurisdiction, Chennai Patent Office. It is in Gindi, Chennai. How to file a patent application? You can be filed through online, e-filing, or by post, or you can directly go and submit your application by hand also. And then this is the procedure for obtaining the patent. Yes. First, after doing all the prior art searches, okay, novelty search, and that statutory pillar search, after drafting the patent application, we need to file the application in the patent office. And then the first stage is it will get published in the patent office journal. Every week, Friday, the journal will get published. So there are 2 types of publication. One is ordinary publication, another one is express publication. Ordinary publication is called 18 months publication. Any time after 18 months, our invention will get published. There is no fee for that. However, if you opt for express route by paying the excess fees, the publication will happen maximum of 2 months. Previously, it will be publishing within 1 or 2 weeks, but now it is getting delayed. So maximum of 2 months, our invention will get published. Then we have to file the request for the examination, or at the time of filing also you can pay the fees. So after that only, the patent office will take up for examination, and they will send an examination report that is called FER, first examination report, for which we have to file the reply to that FER. The patent office will issue the FER quoting certain documents, D1, D2 sort of things, and where we have to defend how our invention is different from the cited documents. And then if the examiner, the controller, is satisfied with our reply, they will grant the patent. Else, they will call for hearing. Sometimes we can receive second examination report also. Okay, and then else they will call for hearing. In the hearing, we have to argue the advantages and merits of the case for the controller to decide, and decision of the controller is the final for patent grant. These are the various documents which are required for filing the patent application. Form 1, this is the form of the patent. This is formal form. Form 2 is the complete and provisional specification. This is the technical form. Form 3 means we have to undertake that in what are all countries we have filed the patent application. That is what Form 3, statement and undertaking of for filing in the foreign countries. If you are going to file your application in the foreign country, you have to file Form 3. Else also you have to find Form 3 stating that we are not filing any application outside India. And if it is filed through an attorney, you have to submit Form 26. Form 5 talks about the declaration of the inventorship. This is also a formal. Only this is the technical form. Form 2 is the technical form. Form 5 is the inventor's declaration will be there. And then if it is coming from another country to India, we have to submit the priority document and then the fees. These are the documents which are required for filing the patent application. So far what I have talking is filing a patent application in India. So I think I made you clear what if you have a scientific invention, you have to check whether it is novel, useful and advantageous. Then check whether it falls under Section 3 and Section 4 of Patent Act. Then draft the application, file your application in the patent office. Once filed, the invention will get published and then they will take up for examination. After examination, we will be receiving the report. We have to file the reply. If the reply is satisfied, they will grant the patent. Else, they will call for hearing and then we have to argue our case to get the things done. So this is the way steps from the invention to the grant. Okay, as far as India is concerned. Coming to international applications, there are two things. One is conventional application and PCT. Conventional application is by national phase entry. Once you file the application in India, within 12 months, this is within 12 months period, you can file into wherever country you want, US, UK, Japan, China. Okay, this is the first route. It is Paris Convention. You can file, these countries will have their own laws. You have to approach the attorney there and then you can file the application. So this is the first route for filing the international application. The second one is national phase entry. This is by new PCT system. So here you can see the procedure. First, we have to file our application in India. Here, within 12 months, you can enter into PCT. India being the receiving office, we can submit our application in India also. Okay, so this is what. Actually here, in this Paris Convention, within 12 months, we have to file the application in US. Okay, which means for filing, filing the fee will come around Indian rupees 7 lakh to 10 lakh Indian rupees for filing a patent application prosecution in US. Whereas here, within 12 months, we can enter into PCT. PCT is a depositing authority where they will receive the applications. Okay, they will receive the applications and they will do the search report and they will do the publication. So in the PCT website also, you will get, your invention will get published. And then if you want to enter into this national phase, you have 30 and 31 months time period. Whereas in here it is within 12 months, you have to spend that 10 lakhs. Here we have 30 and 31 months. Before that, you will be receiving the publication, international publication, search report, everything, so that you will have an idea that whether your invention is really worth it or not. And then you can approach the investors or industry people, and then they can file the international, I mean, entering the national phase into US sort of thing. So as far as if you want to file only in US, you can opt this route. You can evade this PCT filing fees. Or if you want to file in more than 3 or 4 countries, this route will be advantageous. Yeah, the documents required for this PCT application is you have to file the complete specification, claims, drawings, along with the PCT request. Everything has become online now. We can submit online and you will be receiving the international application number. You will be receiving the search report and international report, fees and all. Indian Patent Office, if you are in the India is the receiving office, they will give only in the Indian rupees where we have to pay in the online module. I would like to conclude my talk stating that the only thing that keeps us alive is our brilliance, And the only thing protecting our brilliance is our patents. It is by a famous physicist, Edwin H. Land. If you have any queries, you can.
Ma'am, thank you so much, madam, for that insightful presentation. Now we move on to the question and answer session. I request all the participants to ask their questions in chat box.
Chat box.
Hello,
Yes.
is it audible, madam?
Yes, sir.
Excellent lecture, but I want to ask some very simple questions.
Yes, sir.
You have told after 20 years it will go to public dominion, isn't it?
Yes. Yes.
After getting modifications, again it will go for registration also.
Yes, sir.
After modification, then they will go for registration. If there is no modification, then automatically it will go into public domain. Just
Actually,
like our generic drugs, isn't it?
if there is any modification, we have to file a fresh application, fresh patent.
Fresh application to also registration also.
Yes, the same procedure should go, provided the modification should be substantial and you are
Yeah.
getting a technical advantage.
Here,
I
one
think,
more thing.
yes,
One
sir.
more thing, madam.
Yes, sir.
Here in patent, okay?
Sir, some crosstalk is happening.
No, it is
Okay.
some accidental, I suppose. I have muted it. Sir, you can continue.
Yeah. Yes, sir. Actually, like one day, our invention will get protected only for the period of 20 years. After 20 years, if you have some technical advantage, some modifications, we can go for new patent application stating the modifications, and the same procedure will follow, so that you will get another 20 years of this thing. Hello? Am I audible?
Yeah. Madam,
Next
here
question.
in patent,
Next question you are asking about the next question.
in patent also, two types. One is process patent and product patent,
Yes, sir.
isn't it?
Yes, sir. Yes, sir.
Yeah, that should be. Okay, madam. Thank you. Very nice lecture.
Thank you, sir.
Ma'am, there is one another question in chat box. What are
Yes.
the examination procedure and who will examine invention?
Yes, sir. The examination procedure is after filing the our patent application, we need to submit the examination request, which is Form 18. It is just a formal form with we need to pay the fees. And then what will happen? There are various cadres in the patent office: examiner, assistant controller, deputy controller, sort of thing. Okay, so the examiner only will examine the patent applications, and they are qualified, sir. They are qualified masters or doctorates in engineering or science field. They are into this field only. They will do the search, the search what we have done in the initially, that is the prior art search and section 3 search sort of thing. And they will issue the questions. It is an examination report stating that, look, these are the documents which is related to your invention, and no patent shall be granted. For that, in the reply, we have to file that how our invention is different from the cited document. Okay, how our invention is different from the cited document, and if there are certain suggestions, corrections will be there, you can do all sort of things in there. And if the examiner and the controller are satisfied, they will grant the patent. Else, they will call for hearing, and then the grant or rejection will take place.
Okay, ma'am. We have another question
Yes.
from Devigan Sharma. That is, what are the eligibility and expertise to become patent attorney for any other IPR litigant in India? And how is work culture regulation like Bar Council for regular litigation?
Okay, actually, the eligibility for a patent agent or a patent attorney is they have to have a science degree, basic science degree. BSc, BE is sufficient. as far as this act is concerned. But strictly speaking, if you want to become a patent agent or an attorney, at least you should be masters in your subject. If you are being a chemist or physics, if it is MS, then it is very useful for you to flourish. So the first thing is you have to be a citizen of India. You should complete your age of 21 years, and you should have a science degree. That is technical. It can be BSc physics, chemistry, or engineering, or MBBS, or a BDS. And then you have to write one exam called patent agent exam, which is conducted by Deepa, government of India. If you in that exam, you will be having patent act and patent rules. You have to mug up those things, and then you have to apply for the exam. The exam will be of two papers. Like first paper, it will be objective. Second paper, it will be subjective. And then one, if you qualify in these two things, you can call for an viva OC. And if you qualify that, then you will be a registered patent agent. And advocates are not entitled to handle before the patent office. But if the case go to high court, no, advocates are entitled to argue. But up to patent office, for the signing these things, you have to be a patent agent. You have to have the science degree. You have to qualify that patent agent exam. And still dates, there is no like bar council sort of thing for patents, patent agents. And yes, people are forming, and I am also in a WhatsApp group called PAAI, Patent Agent Authority of India. Only in that level only we are right now. And definitely there are many complaints are going against the patent agent that they are missing the deadlines, they are not assisting. So court is also now directing to have a bar council sort of thing. Anyway, we will get that in the near futures.
Okay, ma'am. There is another question that for law students, there is no practical section as mandatory in the syllabus. So what are your views?
Practical session. Actually, as far as IPR is concerned, for advocate law students, they can flourish in trademarks, copyrights. For patents, you have knowledge up to your +2 level. In the +2 only, you have read chemistry, physics, biology, etc. Right? If you want to pursue in this, there are many advocates who have done Bachelor of Science and Masters of Science in the correspondence course. And after having the science degree, you come to patent, then it will be useful, sir. Yes, it will be very difficult, and you have to depend on a technical person each and every time to understand the concept, everything.
Okay, ma'am. There is another question by Ram Kumar. Is it
Yes.
possible to file patent application more than one country under PCT to get protection for our invention?
Yes. First, we have to file our application in India. After that, we are entering into PCT, and within 30 and 31 months time period, you can enter into whatever countries you want. Those countries, should be designated under PCT. For example, if you take Taiwan, it is not a PCT designated country, which means within 12 months you have to enter into Taiwan.
Okay, ma'am. And there is another question that who can issue patents?
Government of India. Patent, in the patent office, we have to submit our application, and then after all the procedures, the patent office will issue the grant certificates.
Okay, ma'am. There is another question by Kalpana Batre. Is international protection provided only when there is national protection to that product, or there is no any such requirement?
Actually, as far as India is concerned, being an Indian citizen, we have to file our application in the Indian Patent Office. You cannot file your application outside India without filing, that amounts to criminal offense. But there is one thing like filing that one foreign filing license, FFL. If you don't want to file, for example, if you take, microwavable pressure cooker, which is not needed for the Indian people, right? They are having pressure cookers. So in that situation, you can get a permission from the Indian Patent Office stating that, like, I am going to file an application outside India without filing this, for which you have to completely disclose your invention to the Indian Patent Office, where they will check whether it is, they will, so within 7 weeks time period, they will check like if there is anything related to defense or atomic energy or secrecy direction sort of thing. If no such thing is there, they can directly go and file in other countries without filing in India, for which we have to get the permission called foreign filing license, FFL.
Okay, ma'am. Ma'am, someone is asking to share the links for the career for a government in patent roles.
Career for a government
In patent roles.
link. Yeah, see, government, they will call for, patent office will go. Very recently also they have selected some 280 patent examiners, trademark examiners sort of thing. We have to, you can go and reach patent office website, that is ipindia.gov.in. You go there, you can get the daily updates if they are recruiting in patent office, wherever, not only in Chennai, Mumbai, Delhi, Kolkata. You can approach them and you can do the things.
Okay, ma'am. So, is there any question for participants? Please ask on chat box.
Ma'am,
Yes, ma'am.
how much does it cost to get a patent in India?
Time period you are asking?
How much does this cost to get a
Cost.
patent in India?
Cost amount.
Yes, ma'am.
Government fees, it will come around for an individual or an education institution. Government fees will come around 8,100. If it is like industries and legal entities, it is 28,000 plus 12,500. That is, it will come around 40 sort of thing. It is only government fees, and then attorney fees will vary. Some people will do from 30,000 to maximum of 1 or 2 lakhs also.
Okay, thank you, ma'am.
Ma'am, there is another question check box that
Yes. That Ram Kumar Kumara.
yes, ma'am. Can you please elaborate patent on food products, computer software?
Yeah. For food products, previously, India was not a member of TRIPS, that is trade related aspects in Indian intellectual property rights. Trade, okay, where there is no patent right for drugs and foods. There is no patent for food, there is no patent for medicines. After India being member of TRIPS in 2005, from 2005, we can get the patent right for food products and medicines also. As far as food products is concerned, it can be either a product or a process. That is, you can have a formulation sort of thing, like a nutritional dishes sort of thing. And the method of preparation of the food product also, we can get a patent right for that. So we have filed many patents like ready to eat biryani pouch, ready to eat pav bhaji, where you can keep the pouch in the micro oven or a boiling water, it will get cooked. So such kind of product patents are available, and process patents are also there as far as food is concerned. Coming to computer software, if it is only a software, you can go for copyrights. So software or copyrightable subject matter, where you can go for copyright and file it. If you feel that your software can be embedded into a hardware, and this hardware is having a technical advantage, economics, industrial applicability, then you can go for software embedded hardware, that is computer related inventions. Only software means you have to submit, you can go for copyrights, where in the copyright you have to give both source code, object code, what is the program you have used, everything we have to disclose.
Okay, ma'am.
Yeah. Somebody has
Um,
raised hands
Ma'am,
also. Mhm.
Ma'am Devi Prabha here. Ma'am,
Mhm.
I have a particular question with regard to patent agents. So, like for example, if a person want to file for a patent, can any individual can go on directly file. what is the role of this agent and why we have patent agent examination? And if patent agent examination is there, I'm sure that law students cannot write this patent agent examination until and unless they have the science background. Don't you think so? It is restricting a particular individual interest, because being a law graduate, they study IPR, they will have the basic knowledge of how what is patent, what is trademark, copyright. But subject to patent, why is there a restriction? What is your opinion on this?
I'm like actually previously I think it is before 92, I believe. All advocates are automatically patent agents. Then only this restriction has come. Why? Because it is a scientific research. Okay, it is a scientific. If somebody comes to me, I'm a patent agent. If somebody comes to me, means I have to understand the scientific research. What is the invention is. So only having the knowledge of science up to the higher secondary level, it is difficult for them to understand. That is the first thing. The second one is why individual cannot go and file an application, why they need a patent agent. Because it is a techno-legal document which involves both technical and legal aspects. I have seen many inventors, they without unknowingly, they will go and file the application. It will be a very good invention. It is not drafted properly. Okay, it is not drafted properly. So they will lose the patent right if it is not drafted properly. And if they miss the deadlines, the deadlines are very important as far as patents. If you fail to file the Form 18, that is examination report, within 31 months, your patent will get lost. If you fail to file the reply of first examination report within 6 months, the patent right will get lost. So in order to maintain the deadline calendars and in order to protect the invention safely, covering the entire boundaries and not copying the other inventions, this patent agent is everything. And then, like ma'am, it is not like advocates cannot do. Okay, if you have a strong science knowledge, for which if you want to really pursue in this field, after your LLB, go for some science degree. It is for you, and otherwise you yourself will feel inferior that you cannot understand this. See, if you give us a big mechanism for chemistry, will you be able to understand what is electron withdrawing group, what is electron releasing groups? You yourself will get inferior, for the reason only, that is my perspective. But see, what patent office is giving is just a BSc degree. I believe that only BSc degree, you have to judge the scientific invention. In BSc, we will read very less amount only. In masters only, we core into that science and we will understand the things. So it is very important to have a science degree if you want to pursue your thing into this patents, especially patents. If it is copyrights, trademarks, you can very well do that.
Thank you, ma'am.
Thank you.
So, is there any questions? The participant can ask any questions now.
Someone has raised the hand, sir. Excuse me. So somebody has raised the hand, sir. Ramani Garimella.
Yeah, ma'am. There is one question in chat box by Ramani Garimella.
Yes, sir.
That is, not having regulatory, will it affect the business?
No, actually, so far we have not like this thing. But as far as agents or advocates, we have to work based on our ethics, right?
Yes.
Yeah, actually, very recently, I think if I'm correct, one of the patent agent, this thing has been cancelled. Registration has been cancelled because the client has filed a case against him that he has failed to inform the applicant, that is inform the inventor about the deadline sort of thing. And for that, no, we in our WhatsApp group there was big chat that we should have yes, such kind of occupational deficiency also we will be facing if there is any discrepancy sort of thing. Yes, it actually regulatory thing should is important. Maybe in the near future for patent agents also we can have that thing, sir. Are there any state and central government job certifications? Actually, this patent is a central government job only. Patent is a central government job. You visit the patent office website at least once in a week, so that you will get the know things.
Okay,
Ma'am,
ma'am.
yes, any question or can I put a question?
Yes, sir.
Ma'am, actually, I want to know the difference between the procedures of filing design patent and utility patent. How does this are
Actually,
different?
yeah, there is no utility patent in India, sir. Utility patent, that is use patent, that is there in US. In India, there is ordinary patent and design patent. Ordinary patent is you will get the complete protection. Design patent is the function of that product, you cannot get the patent right. The external aesthetic appearance of the product, it can be the shape, or it can be the configuration or something embedded on that product. For that external aesthetic appearance of the product only will get protected under design, whereas here in the patent the functional aspects are being protected.
That means in design patent, the idea won't be protected.
Your idea cannot be patented in design. We have to submit the photograph of the design product, both front view, back view, left, right, top, bottom, perspective view, everything. The final product we have to submit.
Okay, ma'am, got it.
Dear participants, is there any question or let's conclude?
Ma'am, one question. When a formula is prepared, when will it be patented? When it is completely or the time of the process?
Ma'am, come again, ma'am. You?
Ma'am, when a formula is prepared, when will it be patented? Yeah, when it is completely or the time of the process?
Completion of the time of the process.
Yeah,
Ma'am,
yeah.
I think she wants to ask prototype of like that thing. If the
Proto-
model is completely built up, only then it can be patented, or even the idea can be patented. I think, if I'm not wrong. Am I
Strictly
correct?
speaking, actually, strictly speaking, mere ideas we cannot file the patent, right? You have to have the prototype. If it is a product, you have to have the device, and neat pencil drawing is sufficient as far as patent is concerned. And rarest of the rarest, sometimes patent office will ask for the model, the working of the model. We have to submit the video of the model also. See, so far I have filed like some 1,000 patent applications. I have received from the patent office to submit the models for just below 10 only. We have to submit the models. If they ask, we have to submit. Yes, it is not required. But strictly speaking, you have to have the product or the process with you before filing the patent application. For process means you have to get the experimental details. You have to give the evidences in terms of graphs, experimental studies, spectrums, etc. We have to give that.
That means, ma'am, for filing a patent, we'll have to have the design, means the drawing of the product, at least on paper.
Yeah, drawing is important. Drawing is must. That's what very rarest of the rare, patent office will ask for prototype, model, video of the working, everything also. Very rare, sir. See, sometimes they may not be unable to visualize the product. In such case, we have to submit.
But ma'am, in certain cases, suppose I'm just
Yeah.
perspective, the idea is in the brain, somebody has drawn it, And if it is not granted patent and the model is asked, during the process of making the model, this idea will be shared with many people. So what if it gets infringed during the process itself? Then how to? There will be a risk, ma'am.
Yeah, if that is the case, if you feel like they are, there is a chance of being infringed or copied, you can file the provisional application, go for the manufacturing, and then file the complete specifications. Or you can have a non-disclosure agreement between the person, so that he should not use or disclose that into the public.
And provisional application means if we file the idea on the drawing or the drawing, that will be considered as a provisional application, or there is any other different procedure, ma'am?
Come against the position of application. What is that?
No, provisional application you said, no, ma'am, that we should file a
Just
provisional
drawing.
application.
Drawing is sufficient. Without drawing also, we can file the provisional application.
So that's considered as applying for a patent application, or only after the filing? Because why I'm asking, it is from the academic perspective, because in academics what happens, for filing and patent also we used to get some API scores, and granting of patent, the score is different. So if we file only the idea along with the drawing on the paper, will it be considered as a patent
Yes,
application?
it is patent application only. See, what I'm saying, strictly speaking, you have to have a prototype. But you can with the drawing itself also, you can file the patent application, and you kindly ensure that if the patent office will ask for that thing, you have to reproduce that in a prototype. And they will give some time. You say I need some time for doing the prototype, they will give some time. Make sure that it can be reproduced.
Okay, ma'am, thank you.
Ma'am, we have another question from Ram Kumar Kumara.
Yes.
That a kind of curry prepared by my grandmother, which can keep more than 10 days with the same taste, can be filed for patent under food products.
A kind of curry prepared by
Grandmother, which can keep more than 10 days.
Yes, if it is a novel product, if it is a novel product and it won't deteriorate, or you can keep that in the room temperature, yes, we can. Provided it should be nowhere available in the state of art. It should be new.
Okay, ma'am. There is another question. Which law will apply when invention is made in extraterrestrial region?
Which law will apply when actually, if not extraterritorial, if you do the research in US, you can file your application in India also. Which law will apply when the invention is made in extraterritorial region?
Yeah.
That is, which country you are going to file, that law will apply.
No, one confusion generally arises. I just want to clarify this confusion from you. That suppose an Indian making an invention any part of the world, he can file a patent in India. So then after he will be having monopoly over the product in India. The same for having monopoly over a product also in US. Again, US patent will have to be filed. I think in this manner, now numerous patents in all the countries. Yes, ma'am.
Rate of rejection
Yeah.
and reason for rejection. Actually, there is we cannot have the statistics of rate of rejection. If it not falls under patentable subject matter, it can get rejected. What is the reason? Mainly, it should not have new, or it does not have inventive step, or if it falls under section, if the invention is a software, just a software or a method of treatment. That is, the reason will be the three statutory pillars I said: novelty, usefulness, and inventive step. And if it falls under section 3, and then also not disclosing the invention completely in the patent document also is a grounds for the rejection.
Okay, ma'am. There is another question by Ridul Aryan. What is the basic difference between a research paper and a patent application for publication? Like when we file and get patent in academia.
What is the difference between a research patent? Means patent application is a legal right. It is an intellectual property that you can own that property. So if you own the property, you can sell that, you can mortgage it, you can license it, you can assign it. These are the things. Just think patent is a property. So what are the rights you have in a property by owning a house? The same thing you can get in the patent. Publication means it is just to perish, right? You can use the thing in your biodata, that sort of thing. When we file and get patent in academia, no, time period will be, if you go for a express route, within 1 year we can get the patent, right? Yes, minimum of 3 years and maximum of sometimes 15 years also it will take for get the grant.
Okay, ma'am. Is there any question?
Good afternoon, ma'am.
Sorry, wait for a second. There is a question on my WhatsApp. Actually, I could not vision because that participant might not be able to put the question on the platform. Just give me 1 minute to see the question. So the question is like patent is a very dynamic type of thing. So is there any parameters or measures to determine that how during the process of granting of patents? That is the basic question, ma'am. Since it's a very dynamic subject matter.
Yeah, actually, yeah, this is so far what I have explained. No, these are the parameters for determining the patentability of the invention. That is, it should be new, useful, and advantageous, and it should not fall under Section 3 and Section 4 of Indian Patent Act. And then these are the things, conditions which you have to check to file a patent. And after filing the patent, you will be receiving the examination report for which you will file the reply. That's it.
Ma'am, someone is asking to explain that again.
This. Now,
Yes.
okay. The question is what are the parameters that need to be considered for filing the patent? That is the thing, sir.
Yes. Yes.
The parameters are you have to have a scientific invention. That is, it has to be either a product or a process. And it should be new, useful, and advantageous. The next condition. And then it should not fall under Section 3 and Section 4. Section 3, I have said, what are not inventions. That is, method of treatment is not invention. Admixtures, arrangement and rearrangement of known devices, software, these are all non-patent. Section 4 is atomic energy related. These are the parameters. It should be a product or a process. It should be new. It should be advantageous. It should have some use. And it should not fall under Section 3 and Section 4 of Indian Patent Act.
Okay, ma'am. Thank you. So, dear participants, if there is no any question, I think let's conclude. Is there
Thank
any
you, sir.
question?
Yes.
Yeah, you can.
Hello, ma'am.
Yes, sir. Yes, sir.
Yes. I have a question like, can there be a product by process claim? Is there any situation where there is a product by process? Can you explain us?
Actually, process, for example, I'll put it like this. You are having a product, okay, which contains three herbs. For example, tulasi, ashwagandha, atimadram. We will take these three. Okay, this is a product. I can claim it as a compound, a formulation, a herbal formulation for treating fever. sort of thing. Comprises of combination of tulsi, adimaduram, ashwagandha. This is the product claim. Process claim, how I will write no? A process of preparation of this herbal formulation comprising of taking tulsi, grinding with water or ethanol, filtering, and you are getting the extract. Likewise, ashwagandha, I am taking it, doing the fractional distillation and getting the polar components soluble in this. This how you are preparing is the process claim. What is the final product is the product claim. So in the same patent itself, you can claim both product and the process. That is what's product by process claim. That is a claim language, sir. That is a claim language where how we will draft, a, the product prepared by the process. That's how we will claim. A
Okay.
common herbal formulation prepared by the process as claimed in claim 1. That is what product by process claim.
Yes. Thank you, ma'am. Thank you so much.
I think
Thank
thank you for
yeah.
the opportunity given, sir.
Yes, ma'am. Thank you, ma'am. It was very insightful section. So I would like to extend my heartfelt gratitude our esteemed speaker, Dr. Deepa Boppana. Thank you so much for your valuable time and your valuable lessons. In this session, we already discussed the statutory pillars of patentability and the objectives of patent. So it was very good and insightful section. And I further extend my gratitude to all the energetic participants who asked many questions and making this section very, very successful. So let's conclude. Thank you, ma'am. Very.
Thank you, sir. Thank you.
Okay, ma'am.
So all participants are requested to get back tomorrow by 11 a.m. Thank you.